Judges, we just had the last attorney just signed in. We're going to move the judges back to the waiting room for just a minute and admit the last attorney for his instructions, and then move you right back in. It'll take just a second.
He's not attorney. That's the problem.
Oh, he's not?
Right.
Who is he?
We don't know. That's the problem. He's an attorney, but he's not not supposed to be arguing.
Oh. Well, then, I mean, he was on the.
Mr. Wielden, can you hear me? Does anybody, I'll ask those of you who are here, do you know why he's logging into the Zoom meeting?
No, I'm going to call him and tell him he should not be on the Zoom.
Okay.
Okay.
Thank you.
All right.
First District Court of Appeals, 9th session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Morning. We have 4 consolidated cases scheduled for oral argument this morning. The 4 cases are ABC Fine Wine and Spirits, Florida Independent Spirits Association, and Public Supermarket versus Target, Topgolf International, Walmart, and DBPR. The second case is DBPR versus Target, Topgolf International, Walmart, and ABC Fine Wines and Spirits, Florida Independent Spirits Association, and Publix. The third case is DBPR versus Walmart, Walmart Stores East, ABC Fine Wine and Spirits, Florida Independent Spirits Association, Publix, and Target. The final case is ABC Fine Wine and Spirits, Florida Independent Spirits Association, and Publix versus DBPR, Walmart, Walmart Stores East, and Target Corporation. We have allocated 30 minutes per side for the oral argument this morning. And I understand counsel for the respective parties has split their oral arguments. Is counsel ready to proceed? Mr. Treadmill.
Yes, Your Honor.
Again, we have allocated 30 minutes per side for the oral argument. How have you split your time?
I intend to preserve at least 10 minutes for Mr. Hall, who represents ABC, Publix, and FISA, and then 5 minutes for rebuttal. So initially, I plan to take only 15 minutes.
You may proceed.
Good morning. My name is Ray Treadwell, and I represent the Division of Alcoholic Beverages and Tobacco. May it please the Court. What is customarily sold in a restaurant is limited. The plain meaning of that statutory phrase is based on custom, which is widely known. So most of us already know that what is customarily sold in a restaurant is limited. For 25 years, the division listed ready-to-eat foods and beverages as the items customarily sold in a restaurant. There was zero controversy about that limited list until Walmart and Target started alleging that what is customarily sold in a restaurant includes everything in their inventories. But in the first case, petitioners did not present any evidence that restaurants customarily sell anything more than food and beverages. Contrary to the ALJ's finding, the division director never acknowledged or admitted that restaurants customarily sell T-shirts and branded souvenirs. Similarly, in the second case, the ALJ found without any evidence that restaurants customarily sell food that is both cooked and prepared away from the restaurant premises. None of these factual findings should be affirmed due to the sheer absence of any competent substantial evidence. In short, Walmart and Target have had...
Was there any record evidence in the first case that T-shirts were customarily sold in restaurants?
Nothing but the observations of the division director traveling around on his vacations that he might have seen some of these items in a restaurant before, but that does not make it substantial or competent for the conclusion that restaurants therefore customarily sell these items. And so in short, it's the division's position that Walmart and Target have had 2 chances to prove that the division's list is under-inclusive, and they just have not done it. But these consolidated cases also present to this court a basic question of fundamental fairness under the Administrative Procedures Act. May an ALJ rule on factual grounds different than the alleged objections? Both of these cases started off with Walmart and Target alleging that they are restaurants, therefore everything they sell is customarily sold in a restaurant. But the ALJ repeatedly ignored this central basis for the case and instead invalidated the rules on unalleged objections. If an ALJ is authorized to discover new grounds for invalidating a rule either during the course of the proceedings or after the hearing, then an agency cannot possibly litigate these rule challenges on an expedited basis. For the sake of fairness and due process, the division asks this court to rule that an ALJ must ground his or her ruling on the alleged factual objections. Otherwise, the agency...
Excuse me, counsel, are you actually saying that the department was unaware of the argument as set out in the order, in the ALJ's order, that you were unaware that it took you by surprise in any way when you got that order?
Well, I think in both cases we were surprised. And it depends on the argument, obviously, but to the extent the arguments were first raised in a proposed final order, the agency has no chance to respond to a proposed final order, and the agency has no chance to present evidence to rebut whatever new factual ground is being used to invalidate the rule. So I think we have to hold a petitioner to the factual basis that's been alleged, and in this case, in both cases, it was that Walmart and Target are restaurants. So that's where the division focused the attention of the evidence.
So the remedy seeking is basically for this court to overturn the ALJ's ruling. And, what's next? Does that simply mean that the petitioners are going to file a new claim, which simply repeats exactly what Judge Newton's order said?
So typically, if the issue has not been properly litigated, then I guess the court would remand it. But here, remand is not necessary because the court decided, the ALJ decided not to address Walmart and Target's argument that they are restaurants, and instead concluded even if they are restaurants, their locations alone do not establish what is customary in the restaurant industry. And that finding was not appealed by Walmart and Target. And so the central alleged basis for their cases, that their stores alone define what is customary in the restaurant industry, that's been decided in the division's favor. And so we believe the outcome is to rule that the petitioners have not shown that the division's rules are invalid. And on this point of fundamental fairness, I mean, if an ALJ can just raise new grounds for the invalidity of a rule, then an agency might as well be submitting its rules to DOA in advance, much like it does to JAPC and OFAR for review, feedback, and approval. And we just don't see that as the proper mechanism that's been laid out in the APA. But I'd like to also comment on the arbitrary and capriciousness findings by the ALJ on the proposed rule, because those findings present troubling implications for all agencies and puts in doubt whether the division can promulgate any rule here. First, the idea that the division has to have in mind a definition of restaurant. The ALJ's premise that an agency must correctly define each word in a statute during the course of rulemaking is a non-starter. Every rule would risk being illogical and invalid merely because the agency's leadership did not have in mind the legally correct definition of every statutory term.
Counsel,
This kind of challenge. Yes.
Counsel, how could it not be illogical to require the license applicant to know whether they fit the COP requirements if we don't have some form of reasonable definition of restaurant? If we don't define restaurant, how can we define or make a list of what's customarily sold in a restaurant?
Well, I think it goes to the fact that a rule challenge is a facial challenge to the text of the rule. And so if the text of the rule is inconsistent with the legal meaning of the statutory term restaurant, as this court sees it as a matter of law, then I think there's an appropriate challenge here. But going into the work product and the legal behind the scenes rulemaking history within an agency, I think is just is beyond the scope of the APA's mechanism to determine whether a rule is invalid or not. So, I mean, what if the agency had defined restaurant as a large body of water? It would have at least had a definition of restaurant. But if it comes out with the same list, and that the petitioners can't show that the list is incorrect in any way, I don't believe you can invalidate the rule based on the behind the scenes incorrect definition. And again, the ALJ was asking our fact witness what the statutory definition was that arose in 1935, and that's just not a factual question. So the definition of a statutory term is a legal question for this court to decide. It's an issue that we briefed in our legal briefs in our proposed final orders. And so if we start going behind the scenes and figuring out, okay, did the agency define customary perfectly? Did the agency define restaurant perfectly? Did the agency define item perfectly? But we're not focused on the actual text of the rule as it's been published. Then we're invalidating on process alone rather than on the substance, rather than on the facial validity of the proposed rule. And so that's where the division would focus. We have to make this about the published text of the rule and whether that's inconsistent with statutory meaning, rather than look behind the curtain and figure out, okay, did the agency have every perfect thought on its way to the published rule?
Counsel, I'm not sure I followed your answer to Judge Thomas's question. Again, please help me understand how the division determined what is customarily sold in a restaurant without first determining what a restaurant is.
And that logic has an enormous facial appeal. It certainly does. But I don't think we should be expecting an agency to testify to the meaning of every statutory term on its way to publishing a rule. If the agency had used, let's say, the meaning of the definition of public food service establishment, when we should have been using a dictionary definition, it's up to petitioners to show how the actual result of that thought process in the published text is somehow wrong based on that incorrect definition. If we're going behind the scenes, then we've missed the boat on what the rule challenge is actually about. And it also just goes to, when can an agency present evidence? And the case of Department of Health versus Merit suggests we get to defend the actual text of the rule at DOA, and it doesn't matter whether we had the evidence or the proper definition or the proper survey results during rulemaking. And the other aspect of the arbitrary and capricious findings is that the idea that an agency has to conduct a survey of restaurants throughout the state exponentially increases the cost of rulemaking for agencies. And so if we're talking about a survey of hundreds of restaurants, maybe even thousands of restaurants, we just don't know. And once we go down that slippery slope of expecting evidence at the rulemaking stage, there's no limit. And agencies are suddenly going to be asking, okay, well, how much evidence do I need even before a case is brought? And that evidentiary...
The ALJ didn't order that a survey should have been done. Did he not just supplement his argument with a comment that, I find there was little or no investigation or footwork with respect to how this list came about? He didn't actually order that there must be investigations or surveys. It was more of a comment of a lack thereof in terms of how was it put together?
Our understanding is that because the agency did not conduct a survey statewide, that showed the ALJ that the list was arbitrary and capricious. So we actually do read that as being some sort of implicit requirement that if we're going to proceed with this rule, we'd better conduct some sort of statistically significant survey. And I don't think there's any support for that evidentiary burden at rulemaking in the APA. The APA only puts an evidentiary burden on the agency once a rule challenge has been brought. And so during the rule challenge, the division did present the testimony of 2 witnesses who had inspected thousands of restaurants on behalf of the Division of Hotels and Restaurants, who confirmed that they observed the items on the list for sale in restaurants, but not the other items that Walmart and Target sell. Consider for a minute the same statute allows licensees to sell party-type supplies. So if we buy the ALJ's reasoning, then I guess the division also now has to conduct a survey statewide of party supply stores throughout Florida. And you see how this slippery slope of now rulemaking has suddenly become extremely costly, because the division now needs to come out of the gate with evidence in support of the total validity of the rule, even before a challenge arises, in order to stave off this arbitrary and capricious challenge. So I don't see the APA as imposing that kind of financial cost on agencies at the rulemaking stage. The financial cost comes when there's a challenge and there's an actual discrepancy as to the validity of certain text of the proposed rule. And if the petitioners haven't shown a flaw in the proposed text, and neither does the ALJ find a flaw in the proposed text, then we don't have an invalid rule here. And finally, I mean, on this point, the ALJ doesn't even explain, well, how much evidence is going to be enough? So if we uphold his reasoning that evidence needs to be there at the rulemaking stage, then agencies are going to be totally lost as to how much. And secondly, the division did conduct a thorough review of this rule during the rulemaking process. They had no less than 6 rulemaking hearings and workshops. And at those hearings and workshops, the purpose of them is so that the public can come and provide evidence to the agency and help inform the content of the rule. And at the final hearing on the proposed rule, there were no comments criticizing the content of the rule. And so that's what the agency gets to defend, is the content of the rule, not whether or not the division's thought process on the way to the rule is perfect, whether or not we use the correct definition of restaurant. That's a legal question this court can resolve for us. And finally, on the issue of standing, Walmart and Target and the standing is only at issue in the first case, and Walmart and Target admitted no evidence of any plans to actually apply for a license subject to the restaurant rule. Therefore, the ALJ's findings on that was entirely speculative. The second case confirms how speculative it was, because in the second case, we learned that Walmart Incorporated does not even own or operate any locations in the state of Florida. So they could not have applied for a COP license, certainly not immediately. And Walmart Incorporated and Target have to be treated the same in the first case because the evidence was exactly the same between them. So we would ask that this court rule that Walmart and Target did not prove standing in the first case. And secondly, the division would like this court to address the issue of redressability. The idea that Walmart and Target bringing cases to show that only 1 or 2 items may be missing from the rule does not substantially affect their chances of getting a license because of the thousands of other items.
Regarding the standing question, didn't Walmart and Target claim in the petitions and proposed final order that they seek to obtain a COP license and are potential applicants? Why isn't that sufficient for standing?
Because the mere desire to apply for something is not sufficient to show any kind of immediate harm. There actually needs to be some sort of a plan of future action. And I think we cite the famous Supreme Court case, Defenders of Wildlife, on that point. Just an intention without any actual plan just doesn't show an immediate harm.
But in the case challenging the proposed rule, you didn't appeal the standing finding with respect to Target and Walmart East, correct? So there is no standing issue before us on the proposed rule case.
That's correct, Your Honor. We did not appeal the standing of the parties because both of the parties had applied by the conclusion of discovery, and we would like this court's decision on the merits of the proposed rule. Well, so unless there are any other questions.
I do have one more question, counsel. With respect to the standing issue, earlier you made a reference to a facial challenge. I want you to help me understand one of your arguments in briefs. You challenged the ALJ's, you say, mistake or error in not ruling on whether Target and Walmart East are in fact restaurants. But if this is a rule challenge as opposed to an appeal of a denied license, Why did the ALJ have to do that? We don't have a standing issue, and this rule challenge for the proposed rule, it's not an as-applied challenge, it's a facial challenge, as you mentioned earlier. So why would the ALJ err in not reaching a determination on whether the restaurant label applies to those two entities?
Our understanding of the petitions, as the parent on the face of the petitions, is that the grounds for the facial challenge is that there are so many restaurants out there like Walmart and Target, their inventories define what is customarily sold in a restaurant. And the ALJ obviously rejected that argument in the second case on the basis of the word customarily. And so we acknowledge the parties had standing if the case was about everything in their inventories. But to the extent the ALJ narrowed the first case down to t-shirts and branded souvenirs, our position is that Target and Walmart would not have had standing to just challenge the omission of one or two items. It wouldn't make but a de minimis impact on their license potential.
Counsel,
so I would like, yes.
Were Walmart and Target required to have a pending application for the purpose of showing immediate injury?
No, we don't think that they needed to have a pending application. We just think that they needed to show some sort of concrete plans to apply in the near future to show the required immediate harm. So I would like to reserve the remainder of the time, a little over 2 minutes for rebuttal, if that would be all right.
Thank you, Counsel. In view of the questions and answers, we will extend your time by an additional 5 minutes. We will extend counsel for the appellee's time by an additional 5 minutes as well.
Thank you, Your Honor.
Thank you, Your Honors. If I may it please the court. My name is William Hall. I have the honor of representing ABC Fine Wine and Spirits, the Florida Independent Spirits Association, and public supermarkets in this appeal. I'd like to spend probably the majority of my time on the issue of my client's standing, specifically whether they are substantially affected parties with the ability to intervene in these rule challenges, and also as to the proposed rule challenge, whether FISA had associational standing to represent its non-ABC members. But I would like to quickly start by following up on a few of the questions that were asked of Mr. Treadwell. Judge Lewis, to your question about standing for Walmart and Target, the record shows that it is in fact not correct that this rule keeps Walmart or Target from having a COP license. They could open a COP license store today. The difference is they would just have to do it the way Publix has done it. Unquestionably, everyone who's been to a Publix knows they sell more items than are listed in the restaurant rule list or in 565.045. But Publix has created separate liquor stores where it can operate a COP licensed establishment. Target and Walmart could do that today. They choose not to. They want to sell liquor on the shelves of their box stores alongside all of their myriad of other items. A legislative change could get them there, but that's antithetical to the statute. So this rule does not keep them from having a COP. It simply keeps them from having a COP the place they want to have it. Second, Judge Thomas, to your question about defining restaurant, I do think 2 quick points on that, if I may. First, I think it's important to recognize that the last thing Walmart or Target want for purposes of this rule challenge is any promulgated definition of restaurant, because that definition would have to be so broad, and this is admittedly so from their witness they put on, that definition would have to be so broad that it would include funeral homes as restaurants and caskets as items customarily sold in a restaurant. It would have to convert the statute to read COP licensees may not sell anything other than anything in the world. That promulgated definition would help them, but as I don't think I have to spend too much time convincing you, that would not hold up on any reasonable rule challenge. So that's the only definition of restaurant that gets them where they want to go. But really the method of proving what you asked about, which is what's customary in a restaurant, is through the rulemaking process, as Mr. Treadwell stated. That process, as set up by the legislature through 120.54, is one that gives a voice to private entities to go to the department and say, here's what's customary. Here's what we should be allowed to sell. Here's what we believe should be included in this list, to make their voice heard and to work with their regulator on forming that regulation. The interveners did that. We proposed language. We told the department when we liked proposals and when we did not like proposals. The appellees simply chose not to. They never asked for a promulgated definition of restaurant. They never suggested any items to be included in the rule. It's simply an argument to try to poke a hole in the rule and frankly keep the department in a litigation spin cycle. It's not an argument that actually gets them anything. So I think that's important to recognize. And frankly, if the department had some definition of restaurant beyond what is just the common ordinary definition, since much like in a statute, an undefined term simply must be given its plain and ordinary meaning. If they had any different definition in their minds, that would be an unadopted rule. So they could not legally have a definition of restaurant that isn't A, promulgated, or B, simply reflective of the common meaning of that term. Moving on to my client's standing, unless your honors have any specific questions on those points.
Do you agree with the division that it's the court's role to define restaurant as opposed to the division?
So I don't think that anyone, frankly, has to define restaurant. I think by not defining restaurant, the division has told licensees, much like the legislature in not defining a statutory term, has told anyone following that statute default to the common meaning. So I don't believe this court or the division has to define that term because the dictionary and plain meaning defines it for us. So I don't believe it is necessary in this case, if that answers your question. Yeah, thank you. So moving on quickly, if I may, to my client's standing, Section 120.56 is crystal clear that whether a party can challenge a rule and whether a party can intervene either in support of or against a rule, it's the same test.
Counsel, what is the intervener's substantial interest under Section 120.56(1)(a)?
So for intervention, it would be 120.56(1)(e), although it's actually the same language. So either way, same point I was making, both are substantially affected. So two points on that, Judge Lewis. First, under this court's decision in Coalition of Mental Health Professions, which it's also cited in REEF, in Televisual Communications, which we've cited in our briefs, and the Ward case in the 4th DCA, this court has made clear that if a party is regulated by a rule, then they are substantially affected. They are substantially affected parties, period. In fact, in Coalition of Mental Health Professions, this court said that no further elaboration is necessary, which makes complete sense. To find otherwise would be to say, for a liquor licensee in this particular case, your legal rights as to what you can sell will be decided around you. You'll have no voice on what you're legally allowed to do. Whereas, because they are regulated by this rule, frankly, any party would want to have their voice heard to the extent they feel it impacted them. If the court is going to look beyond that, as the appellees asked, which we think is contrary to those opinions, you need to look no further, frankly, than the Dania case, which we've cited repeatedly.
However, the ALJ cited KM versus Florida Department of Health,
Sure.
cited 237 Southern 3rd, 1084, in support of his finding of a lack of standing of the interveners. Can you distinguish the KM case?
Absolutely. So the KM case, which is from the 3rd DCA, was the repeal of regulations relying on cardiac care. It wasn't a situation where all cardiac care would disappear, simply that cardiac hospitals or cardiac practitioners no longer had to follow certain regulations. The injury that was alleged there was by no longer having this regulation, we risk getting worse cardiac care than we did before. The 3rd DCA found that was speculative. What we have here is not a situation where we risk, again, based on the petitions that Walmart and Target filed, which again, I would remind the court, what they sought and what actually gets them something is repealing this rule altogether and leaving an ambiguous statutory phrase undefined. So it's not a situation where we risk a worse restaurant rule. We risk no restaurant rule at all, which means that my clients, specifically small independent retailers, family liquor stores, family-owned liquor stores, would be forced to simply guess as to what's customarily sold in a restaurant. So it's not a scenario where they risk lower quality regulation or lower quality guidance. They face no guidance whatsoever. It would be in—
Counsel,
Yes.
Do small family-owned liquor stores typically get full COP quota licenses?
Absolutely. A bar would be a perfect example.
Okay, that's something, obviously a bar is not what I'm talking about. I'm talking about a package store. Maybe not obvious, but that is what I was talking about. But, I had made a note and then I never looked in the record to answer my question. What exactly kind of license does Publix or ABC have?
So Publix and they have COP licenses. It's actually undisputed, and the ALJ did find that Publix has one COP license, ABC has multiple, and the number is actually included in the FISA chart. I believe it would be upwards of 30 COP licenses. The other licenses they have are package store licenses. But to give an example, a Tallahassee example, if anyone's been to Market Square Liquors in Tallahassee, they have the one on Timber Lane, they have a packaged liquor store, and right next door is a bar where they serve drinks by the glass. There are also entities that now allow you to, frankly, drink while you shop, to have a glass, some kind of alcohol while you shop. So it is possible for those entities to have COP licenses, but it's undisputed that they are regulated by that rule. And based on Coalition of Mental Health Profession, that's all this court has ever asked. To go in beyond that would go, and I apologize, I actually got off track of part of my answer to you, Judge Lewis. The Dania case is a perfect example of what we're facing here, a situation where all regulation as to what a statute meant would be gone. That's the equivalent. And what this court found was that's an improper place to put a private party in because they simply have to guess as to their conduct. As to the associational standing portion, it's really a pretty simple question before this court. Did the law require that upwards of 30 separate entities intervene individually in this case, as opposed to through their common association? Quite obviously, it didn't. It wouldn't have been in any party's interest, this court's, DOA's. It's not ever what the rule has, what the law has required in this area. And looking at some examples of where a court has asked about how many members are affected for associational standing, oftentimes this court never even asked that question. The Rosenswood case is one example. But if you look at the second DCA, the Hillsborough County case, that was a situation where 37 out of 2,000 was deemed a substantial number. I simply know of no facts or anything that could make that a substantial number, but FISA not, especially when you consider that ABC intervened on its own because it had the means and intention to do so. So really, we're only talking about the 36 out of 85 non-ABC members of FISA who have COP licenses. That's coming up on half. If that's not a substantial number, then I don't know what is, based on this court's precedent, especially in light of the Hillsborough County case. In your honors, with that, if your honors have any questions, I'm happy to answer. Otherwise, I'd be happy to reserve the rest of our time for Mr. Treadwell and rebuttal, and simply to ask that you please respectfully reverse the portions of the two final orders that we've challenged in our briefs in here today. Thank you very much.
Your counsel.
Please the court, Elliot Shurker on behalf of Walmart. I've divided my time with Mr. Spicola 20 minutes and 10 minutes. I'll be addressing the merits of the ALJ's ruling, and Mr. Spicola will be addressing the standing. The ALJ did not go, as the division puts it, behind the scenes to address the vagueness of the existing restaurant rule. That's the 2018 order. The ALJ ruled that the restaurant rule on its face is vague, fails to set forth adequate standards, and vests unbridled discretion in the division. The ALJ further ruled that the rule is arbitrary and capricious, starting with the ruling on vagueness. As this court held in South Baptist Hospital of Florida, an administrative rule is invalid under section 120.52H(d) if it forbids or requires the performance of an act in terms that are so vague that persons of common intelligence must guess at its meaning and differ as to its application. The ALJ relied on that definition to declare on page 270 of the record that the rule violates subsection 8D because it, quote, provides no guidance on how the division will determine what is customarily sold in a restaurant. And the correctness of that ruling appears in the restaurant rule's own text. It appears in the text of the rule. After listing 7 categories of items that are customarily sold in a restaurant, the existing rule states that, quote, a licensee may petition the division for permission to sell products other than those listed, provided the licensee can show the item is customarily sold in a restaurant. There are no standards in the rule on how to determine whether an item is customarily sold in a restaurant. As the ALJ found at page 270 of the record, the division's representative could not provide a definition of customarily sold or of restaurant, nor could he, quote, describe the standards that the division uses to determine whether an item was customarily sold in a restaurant. To the contrary, Director Philpott testified on innumerable occasions in his deposition that each case would be resolved by, quote, consultation with counsel, and that there are no standards in the rule for determining what a restaurant is or what is customarily sold in a restaurant. What the ALJ ruled was that this demonstrates, quote, the division's inability to articulate the standards of the rule, and hence the vagueness of the rule and the breadth of discretion it vests in the division. That conclusion, we submit, mirrors the JASPC's 1994 finding, which appears in the record at page 25. Absent explanatory criteria, use of the word customarily vests unbridled discretion in the division. We rely on this court's decision in the Peter R. Brown case. That involved an administrative rule that forbid the expenditure of state funds for decorative items and listed examples: globes, statues, potted plants, picture frames, etc. What this court held is that the rule is vague because no qualifying language is available as a standard to determine what items are covered and what items are not based on the examples. A wide range of things can be considered, and different people can guess at its meaning or come up with various interpretations for decorative items. So too here. And the arbitrary and capricious finding. The ALJ ruled that the rule is both arbitrary and capricious because the evidence of the hearing establishes, the ALJ found in 271 through 72, that restaurants customarily sell at least t-shirts and branded souvenirs, but those items are omitted from the list of items customarily sold in the restaurant. The ALJ ruled, quote, excluding an item that the division acknowledges is customarily sold in restaurants from a list of items customarily sold in restaurants is illogical, such that the rule is arbitrary and capricious. We submit that ruling is an eminently correct application of the statutory prohibition.
Regarding the intervener's standing arguments, would you agree that the fact that a party is regulated by a rule is alone sufficient to establish that their substantial interest will be affected?
Judge, if I might defer to Mr. Spicola on standing, he's going to be presenting all the arguments on standing on behalf of all the parties, including Walmart, and request that the court pose that question to him.
Okay.
If I might turn to the 2019 order, which is the proposed rule. And I note that Mr. Treadwell seems to conflate both the existing rule and the proposed rule in making his argument. These are very different issues and very different rules and very different rulings by the ALJ. What the ALJ ruled on the proposed rule is that it modifies or contravenes section 565.045. That was the first ruling by the ALJ. On its face, the rule modifies or contravenes the statute. Now, why is that so? The statute prohibits the sale by authorized vendors of alcoholic beverages of, quote, anything other than the beverages permitted, home, bar, and party supplies and equipment, cigarettes, and what is customarily sold in a restaurant. That's the statutory language. The proposed restaurant rule states that, quote, items customarily sold in a restaurant shall only include food cooked or prepared on the licensed premises, hot or cold beverages, souvenirs, and gift cards or certificates. The ALJ therefore ruled that to meet its statutorily imposed burden, because with a challenge rule, the burden is on the division. The division was required to prove that these are the only items that a restaurant customarily sells. The division spends a lot of time arguing about what a restaurant is, and you heard some of that argument here this morning. The ALJ did not rule on the basis of one of our arguments, and that's correct. The ALJ did not rule that everything that Walmart and Target and others and Topgolf sells is an item customarily sold in a restaurant. That issue was taken off the table. But what the ALJ did rule is that the division has no definition of restaurant. At record 849-50, the ALJ notes the division stated that it does not, quote, have a position on the definition of restaurant, so that it is entirely proper to use the dictionary definition of restaurant. And this court relied on this court's decision, and the ALJ rather relied on this court's decision in Salvation Limited, which we believe completely addresses the issue. The administrative rule in Salvation Limited exempted restaurants of a certain size from limitations on the number of liquor licenses to be issued by the division. As here, the rule did not define restaurant. The challenge rule, however, defined restaurant as a place where meals are prepared and served, and required that the food be prepared on the premises. This court held that because the rule did not define restaurants.
Excuse me, let me interrupt you for a second. And certainly I recognize that we've got different issues and different standards with respect to the appeal of the existing rule versus the proposed rule. In looking at the proposed rule, subsection 3, it's been stricken. And that was the catch-all phrase where if there was an item not expressly enumerated, a licensee could come in and try to acquire that to be added to the list or somehow consider that in their license application. I understand that striking that portion probably arose from the ALJ's initial order on the existing rule because the issue became you concede their items not on the list. And so you basically conceded it's not a limited all-encompassing list. And especially since you said there may be more. So we have subsection 3 stricken probably because of the first order, but in the proposed rule challenge, what if subsection 3 was added back in so that the burden of the division listing every specific item was lifted somewhat, and a licensee or a license applicant could come in and say, I sell items not on this list, but will you consider my list, so to speak? So what if subsection 3 was added back into the proposed rule? Would that change your position with respect to whether it was valid?
The addition of subsection 3 back into the proposed rule would raise the same vagueness issue as the existing rule, Your Honor. There are no standards for determining what is customarily sold in a restaurant in the existing rule, and importing it into the proposed rule would simply create a vagueness issue as to the proposed rule. It would put us right back in the same position we are with the existing rule. Now, I note, Your Honor, that Mr. Treadwell referred to the extensive proceedings that the division conducted before the rule was adopted, and that's where we find, for example, that the division was responding to the original order on the 2018 order on the existing rule. But I think when the court reviews the transcripts of those proceedings, the court will find that they were basically a warm-up act for the argument we're having today. That is a back and forth between the division and various representatives of interested parties as to the meaning of the rule and the meaning of the word restaurant and the breadth of the rule. But the important thing that I think we'll find from those proceedings is at page 3712 of the record, where a question is posed to the division's representative. Has the division done any type of investigation, study, or survey to determine what merchandise or services are customarily served at restaurants? To which the division representative responded, no. And that's the basis of the arbitrary and capricious finding as to the proposed rule. It is not that.
So it's arbitrary and capricious anytime you don't conduct a survey, do a statewide survey to determine what is customary?
When you don't have a defined term, it certainly is wrong. Because the dictionary definition of restaurant, which we're presumably going to have to use because there's no definition in the rule, is a public eating place. That's all. A public eating.
Let me ask you this then, counsel. You know what? I'm going to right here and now appoint you director of the Division of Alcoholic Beverages and Tobacco and tell you to enforce 565.045. What does your rule say, or do you have a rule at all? It seems to me, the division is trying to make efforts to comply with the statute that has some undefined terms. What should they have done? Not what did they do and what's wrong with it, but what should they have done?
Well, first of all, as the ALJ ruled, You either have to have a definition of restaurant, or you have to live with the definition of restaurant as a public eating place, in which case the proposed rule goes. Because as in Salvation Limited, it restricts restaurant to a place where food is cooked or prepared on the premises. That definition wouldn't be able to survive. So that definition would not be able to be used.
So a restaurant is a public eating place. Anything else?
The second thing I would do in my new position would be to follow through on what the ALJ said. There are 50,000 licensed places in the state of Florida. It wasn't until Costco applied for a permit that the division ever denied a COP permit. And as the director admitted, there are wholesale across the state of Florida operations that sell all sorts of things. True, the ALJ rejected that as a definition of customarily defined, but the court can review that evidence and see that everything from bait shops to movie theaters have COP licenses. It isn't that difficult for the division to do its job based on its own records and come up with a definition of what is customarily sold in restaurants. The division director himself acknowledged that the definition of restaurant has changed dramatically since 1994. I heard Mr. Hall say that there are operations where people are encouraged to purchase drinks at the bar or at the facility in a larger operation and essentially sit and shop as they go through the stores. The definition has changed. The ALJ recognized that the division did nothing to determine what is customarily sold in restaurants. So the first thing I do would be to either live with the definition of public eating place or define restaurant. And the second thing I do would be to discharge the duties that the ALJ says that I have, that have never been discharged by this division. And then come up with a definition. In other words, not impose the definition from top down, but do the due diligence first.
Once you define what is a restaurant, what standards would you use to determine what is customarily sold in a restaurant other than what the division did in this case?
I would do my due diligence and take a look around the state of Florida, because the current director already admitted that operations throughout the state of Florida that have COP licenses and might be called restaurants sell all sorts of things, from movie theater tickets at the movie theater to everything that's sold at the Daytona Speedway is sold by an operation that has a COP license and could be called a restaurant. So first I do my due diligence, and then I would create the rule. And that's why the ALJ ruled that the proposed rule is arbitrary and capricious. It's not that it has to be everything we say, it's that it's the division's burden to come up with a rule that accounts for what is actually customarily sold in restaurants at the present time.
Counsel, aren't the workshops exactly what kind of due diligence is required by the statute for rulemaking? I mean, they had workshops here. My understanding, I apologize to Mr. Treadwell and Hall, I forget which one said it, but your client said nothing at these workshops, which could have given them a little bit more guidance on creating this rule. But isn't that the due diligence that's required under Chapter 120?
Right, I disagree. The workshops were arguments, with the division not giving an inch on the definition of restaurant and the definition of customarily sold. They're basically, as I said, a warm-up act for the argument that we're having today. What the division has is this storehouse, this treasure trove of information as to what is customarily sold in restaurants throughout the state of Florida in the modern era, not in 1994. It doesn't need to spend a whole lot of money or do a whole lot of legwork to do the due diligence to determine it, because they already know. They already know that the director basically admitted that he thinks the rule is essentially being wholesale violated by operations in the state of Florida, and everything from movie theaters to the Daytona Speedway to bait shops to whatever operation has a COP license. So they know what's going on in these operations in the state of Florida. They have inspection authority, and they can go in and take a look at any operation and develop the database to determine what is customarily sold before defining what is customarily sold. And that's not an undue burden. That's what the burden that's imposed on a regulator under the Florida administrative scheme in coming up with a rational basis for a rule. Otherwise, we have exactly what we had in Salvation Limited, which is no definition of restaurant, no definition of customarily served, and a rule that ignores the reality in the state of Florida. The ALJ's rulings on arbitrary and capricious, I think, make that point precisely. The definition of an arbitrary and capricious rule is in subsection DE. And a rule is arbitrary if it is not supported by logic or necessary facts. This is not something we're making up. This is imposed by the legislature. And secondly, it's capricious if it's adopted without thought or reason or is irrational. The ALJ's determination in paragraph 104 of the order, which appears at record 873, is that in rulemaking and at the hearing, the division declared its list of what was customarily sold in a restaurant without first determining what a restaurant was. This is, according to the ALJ, illogical and irrational. A list of items customarily sold in a restaurant resting on an incorrect or non-existent definition of restaurant is illogical and irrational from the beginning. And then the second step, the division in paragraph 105, the division compounded the illogic and irrationality of the rule by creating a list of items that is not based upon any factual examination or evidence about what restaurants, whatever the definition, actually sell. The division did not prove that the items listed in the proposed rule are the only items customarily sold in a restaurant. So ultimately, the division failed to present evidence of logic, facts, or rationale to support the proposed rule's limited list of items customarily sold in restaurants. This is not a matter of the ALJ ruling on anything that was not put into issue by our petitions in both cases, and certainly not by our petition as to the 2019 order. The ALJ ruled on the face of the record that the division simply didn't do its job in promulgating the proposed rule and is required by the statutes to have a logical and fact-based basis for the rule that it adopts, and it simply didn't do that. Thank you very much.
May it please the court, William Spicola on behalf of Topgolf, Target, and Walmart. To start off with, the simplest explanation is often the most elegant. It's undisputed that Topgolf has standing to bring the rule challenge to the existing rule. They were a licensee faced with discipline. That's as far as this court needs to go. Topgolf has the standing. The rule is obviously invalid because of the provision that vests the division with unbridled discretion, and that's as far as this court needs to go. However, moving down to the proposed rule as we discuss Walmart and Target standing, both Walmart and Target are bona fide applicants for licensure, and therefore they have standing to bring the rule. The rule will affect their ability to get a license, and in fact, Target's license was denied. Target's license application was denied subsequent to this, however, not on the basis of the rule or proposed rule. But either way, as a potential applicant, they have an interest in having a voice in challenging the rule that will affect their ability to get a license. And then finally, moving on to the standing of ABC, FISA, and Publix. The first prong of the test to determine standing is whether or not a party will suffer a real and immediate injury effect. It is clear from the record in both cases that Publix, FISA, and ABC cannot demonstrate any clear injury effect. It's just that simple. The only possible outcome this case could have for them, both of these cases, is the elimination of restrictions on what they can sell at their place of business. We're not talking about the quality of pediatric care. You know, the bottle of Jack Daniels or Smirnoff is going to be the same regardless of whether or not this restaurant rule exists. It's simply whether or not this rule, it's simply whether or not they will suffer a real or immediate injury effect. And they just cannot demonstrate that they do that.
The interveners cite DBPR versus Daniel Entertainment Center, cited at 229 Southern 3rd, 1259, which is a 2017 First DCA opinion, in support of their contention that loss of regulatory guidance can result in an injury sufficient to support standing. Can you distinguish the DPPR case?
Yes, sir, Your Honor, absolutely. Dania specifically dealt with the loss of a rule that clarified card rooms' ability to play a particular legal series of designated player poker games under Florida statute. The loss of regulatory guidance at issue at Dania was the loss of the clarity as to whether or not they would be allowed to play those legal designated player poker games under Florida law. So yes, there is an obvious distinction. Dania has to do with imposing an additional restriction on these licensees. If that rule were to disappear in Dania, that loss of regulatory guidance would mean exactly that, an additional restriction on their ability to operate a legal designated player poker game at their facility. So that is the loss of regulatory guidance that we're talking about in Dania. It's the loss of that, it's that restriction on their ability to operate. The ABC, FISA, and Publix can show no additional restrictions on their ability to operate based on this proposed rule. And that is why the ALJ correctly found that they do not have standing. TVC deals with the restriction on the ability of, that they cited, deals with the restriction on their ability to provide audio instruction. The case in Reef dealt with psychologists at a public hospital, and the bylaws of that public hospital placed restrictions on the abilities of those employee psychologists to practice psychology inside the confines of that hospital. That is what that loss of regulatory guidance is, the imposition of those additional restrictions. In Reef, the Reef had to deal with the ability of a gentleman that installed docks to meet his statutory duties as a professional engineer. It set certain requirements for that person to get to that, to engage in their profession. Not being in compliance with that rule would restrict him from being able to earn a living. No outcome in this case will restrict the ABC, the folks at FISA or Publix ability to sell the liquor that they want to sell. All it will do is change their ability.
Excuse me, counsel, do I misread? I think it's Coalition of Mental Health Professionals that the fact alone that an entity is regulated or falls under the regulation of a rule is generally enough to confer standing. It sounds like you're saying that there's a lot more that they have to prove to confer standing.
I don't think I don't think it is a lot more, Your Honor. I just think it has to be that first prong of the test, that real and immediate injury effect. The loss of a completely illegal regulation cannot be a real injury. If the loss of regulatory guidance saying that they're allowed to, I don't know, they're allowed to sell illicit drugs in their stores, is that some sort of injury? Should they be allowed to intervene to support that? Absolutely not. You don't get to intervene because of a simple loss of regulatory guidance. The test still stands. It has to be an injury. They can't demonstrate any injury just because of the loss of regulation. In every one of the cases that is cited, there's an additional restriction or implication that the loss of that regulation is going to have on that individual. It's not it's plain and simple. The gentleman wouldn't be able to install docks anymore. In Ward, yeah, exactly. I apologize. Ward was the professional engineer that had to do with the installation of docks. Again, it's simply based on a restriction on their ability, and ABC, FISA, and Publix are unable to demonstrate that, and that is why they don't have standing. And with that, I conclude and reserve the rest of my time for Mr. Sharp.
Counsel, before you conclude,
Yes.
I pose a question to you. Could you address petitioner's argument that if we invalidate or affirm invalidation of the existing and proposed rule, there will be no guidance?
We don't have any guidance now, Your Honor. What we have is an invalidated rule, and then we have a proposed rule that has been found invalid. So I agree, if there will be no guidance, but that's because of the failure of the division's rulemaking, not because of any actions of Walmart or Target or Topgolf. It's the division's burden to put these rules out and their burden to put the regulatory guidance out. But let's not get away from the fact it's ABC, FISA, and Publix's burden to demonstrate a real and immediate injury, and they just can't do that in this instance. And without any other questions.
Counsel, as to FISA.
Yes.
Didn't FISA prove a substantial number of its members are affected by the rule?
They are absolutely affected by the rule. However, the invalidation of the rule would only allow those members greater flexibility in what they're able to sell in their business. What they're asking for is, hey, we need a list of things to put a limitation on what else we can sell besides the liquor. And my argument is that is not a real immediate injury. If they're allowed to sell more things, if the only outcome that these cases can have is that they're potentially going to be able to sell more items, that's not an injury. Regulatory guidance in and of itself is not a panacea. It has to be legal regulatory guidance. And with no other questions, I conclude. Thank you very much.
Should I wait until the clock resets?
That Mr. Stecker does not have an additional argument since he reserved some additional time for you. If you do not, then the floor is with the appellates for the rebuttal.
That is the conclusion, then, Your Honor. Thank you.
Thank you.
Thank you. We continue with this facial challenge to the division's rules, and yet we still haven't heard what is actually incorrect with the text of the proposed rule. And that's where we have to stay focused on the text and not the behind-the-scenes definitions the agency may or may not have had in mind, or what evidence that the division could have collected in addition to what it collected at the rule hearings and workshops. We can't go into this behind-the-scenes rulemaking history and the internal thought process. Like Mr. Hall pointed out, if the division were to have some sort of behind-the-scenes meaning of restaurant that's not the plain and ordinary meaning of it, then we would have to promulgate it in rule. And so we applaud the division representatives for not answering that legal question. Well, what does this statutory term mean? We think that should not be a question for a fact witness, and it certainly should not have been the ALJ's basis to invalidate the rule based on some agency leader's definition that he or she may have had in mind. Mr. Shirker suggested that the Division of Alcoholic Beverages has a treasure trove of knowledge of what is customarily sold in a restaurant, and that's just not the case. There's no duty in the beverage law for the division to collect this information, and it's just not in the division's information that it currently has. So it has to conduct these rule hearings and workshops and make a good faith effort to try to draw this line that is faithful to what the legislature intended here. And the restriction is the legislature's making, not the division's making. And so we have to have some method of, I guess, giving some sort of guidance and standards to implement this statutory restriction. And if the idea becomes we have to conduct a study of restaurants, well, if we're going to use the petitioner's definition that a restaurant is as broad as any public eating place, then we don't have a finite universe of restaurants to go survey. We wouldn't have the finite universe of, let's say, public food service establishments to go off, because who can tell what is a public eating place and what is not? Is it a public park where people can picnic? We just don't have any idea of how to find what may be considered a restaurant under the dictionary definition. And secondly, I'd like to point out that the burden of proof here is not on the division to prove definitively that the rule is correct against all challenges. The only burden on the division here is to show that the rule is logical and rational in the face of the particular challenge that comes against it. And here, the particular challenge was the rule should include everything Walmart and Target sell. And if we're going to go into specifics on whether T-shirts or potato chips, the framework of evidence set forward in Consolidated Tomoka holds that the petitioners have to put forward some kind of evidence that restaurants customarily sell these items before the division then has to rebut that by a preponderance of the evidence. And a couple other points. Mr. Hall mentioned Publix having 4C or having consumption on premise licenses. We want to make very clear those consumption on premises licenses apply to their liquor stores. And so at their liquor stores, they're selling no more than what's in the proposed rule. Those licenses do not apply to the grocery stores. And to the extent Mr. Shirker is making an issue of bait and tackle shops and a whole lot of other locations that he considers the division is licensing inconsistently with its actions here, that's just not in the record, and the ALJ found that evidence wholly unpersuasive in terms of any kind of comparative analysis. And you might have noticed the division filed recently a case that was just decided at DOA on this comparative analysis point, and so that case may actually be coming. But the division just made a good faith effort. We didn't define restaurant in the rule, but we think that the rule is still valid under the plain and ordinary meaning of what is customarily sold in a restaurant, however this court chooses to define those terms. And we feel that the rule cannot be invalidated unless the petitioners show where the text went wrong. We shouldn't be going behind the scenes to the process the division used to get to the published result. We should keep these challenges as facial challenges and put the burden on the petitioner to prove where they think the text is wrong here. So unless there are any other questions, the division respectfully requests this court to reverse the ALJ's findings that we have appealed.
And
thank you very much.
Councils, for your respective oral arguments this morning. We stand adjourned.